day.
One word prayer. Justice. Justice. Where are you?
Okay, Linda, what day is it? I'm looking at my calendar here. It can't be Friday because there's too much going on.
It is Friday, and
It is
it's the Friday. It's a Friday document. Judge Cannoni was very active up. We were supposed to just do questions and answers from our viewers today. Remember, Michael Bryant? We promised.
Vaguely remember that.
Yeah, and somehow that has morphed into now we have a full-grown show here. I keep having to tell all my girlfriends and all, I can't go out anymore. I no longer can be a night person. I can no longer meet anyone for dinner because we have viewers. And after today, Michael Bryant,
that's funny. I was telling your girlfriends the same thing. That's so weird. We got tons going on, and I had a little court action myself today, which is why I didn't quite get a chance to change completely. So I was either in court today or I'm going to be your server for tonight. So one or the other. Think about what's on the menu. Try the specials. Okay, where do you want to start this mess? Obviously, we're talking about the Karen Reed case.
With our breaking news.
We do have some. I do have to find that. Sometimes I'm not quite prepared. Let me see if I can find where the breaking news actually disappears.
Today was our day off. Today was our one day off.
Yeah, well, doggone it. I know I got that here somewhere, and I wish I could find it for you. So let's just chat for a little bit. I'll find it. Go ahead and go ahead.
As I expected, and I always said to you that Judge Cannoni likes to issue opinions at the end of the day. And boy, did she just come down with one. And we were reading it as we were about to go on the air here. The breaking news is there is a gag order. A gag order, or as my little fingers would like to say, a gaga order, because I tend to type with my nails and they tend to. And anybody knows me.
Oh, there it is.
Typing is not my forte. Here we go.
Oh, I'm sorry. Go ahead.
It fooled me again. All right. An 8-page. It's the longest order I've seen in this case. And it comes after something really interesting. But before we go into the specifics of the gag order, I would like to set up something that happened, a document that was filed later on before the gag order. And it was a document filed by Special Prosecutor Hank Brennan to correct the record. And the reason I say this feeds into the gag order is because you and I spoke about what Mr. Brennan has done. He says it was unintentional and regrettable. The first time was telling everybody who could hear, who was watching on social media, that indeed, that the defense hadn't provided documents, the emails and the bills regarding the ACA people. Okay, everyone got a pass on that. And then the other day when we were watching on Wednesday, the argument on the motion to dismiss and all, at the very end, there was an argument by Prosecutor Brennan about David Yannetti making extrajudicial statements that were totally in violation of the rules of ethical conduct, professional ethics rules of professional responsibility and all. And Yannetti got up there and was furious and said, I did nothing of the sort. Okay. What Brennan had cited to was a court TV interview. What it was a court TV program that had taken clips of things that have occurred in the public, including a Zoom conference that was on the record about the case, and said that Yannetti had violated the rules of professional conduct. Hence, I want sanctions against the defense for this and for other things that the client of Mr. Yannetti had done, that's Karen Reed, and Mr. Jackson regarding interviews that he had given with Ted Daniels and with an interview that Gretchen Voss, because that the court opened up that interview to the public the other day. And today, lo and behold, we have this affidavit from Hank Brennan who says, I mistakenly stated that Yannetti's statement was an extrajudicial statement. 9, that's paragraph 8. Number 9, my mistake was unintentional and regrettable because it was not. It was a statement made during a Zoom court hearing in the Reed case, and the segment included a court TV anchor's story on the case. Now, anyone who watches these shows knows that when you put this together, you're putting clips together. So he's a seasoned attorney, all right? And so what happened, He gets the pass because it's unintentional and regrettable now, twice, all right? But then right after this gets filed, as we're like, Missy's loading everything into the prompter
Yeah,
here.
this is me scanning through this for you,
Right.
just so we can hit some of the high points that you've just
Yeah,
referenced here. I mean, this is basically his mea culpa, right?
right.
And you know what it should say at the very top is never mind, because he obviously you know was off on his own, cowboy in this thing, and somebody else probably pointed out if Yannetti had not done so, somebody else on the team should have.
Right.
Paragraph 5 there, the statement was aired as part of that segment posted by Court TV, edited, entitled Karen Reed's attorney talks federal investigation with Court TV. And then they cite the time of the segment. And in 7 is a quote from Anthony Yannetti that was a statement Mr. Yannetti made during the Zoom court proceeding. So number 9, oopsie.
Oopsie,
And
unintentional and regrettable.
regrettable. So
Now,
my bad.
also, if he didn't watch the Court TV interview before he represented that to the court, but what it did is it damaged, in my opinion, the defense. Now the defense has this pall over them that, oh, everything they do is wrong. And oh, by the way, even though if the mea culpa is here from Hank Brennan, the gag order mentions Karen Reed and all. It doesn't mention the regrettability and the statements made by Hank Brennan. It mentions because why? Because they were made in court, even though the effect is huge. It's huge because everyone's watching the court proceeding. Not everyone's watching the interviews that occur with reporters. And as a matter of fact, no one even knew what Gretchen Voss's notes were, right? Until they were opened the other day on Monday.
Well, yeah, some of them were and some of them were protected. But I also think that this makes the prosecution look schlocky. You know, yeah, there may be some perception that the defense was trying to pull something, but this, you don't see this very often. You don't see an attorney have to reach out to the court, file a public document that says, "Man, I screwed that up." And I think it makes them look bad. So it's not helping anybody. I think it makes the prosecution look worse than whatever little bit of taint there might have come for the defense.
Well, except that people aren't paying much attention to this, right?
Why aren't they? We're talking about it.
Well,
Why aren't they paying attention?
And everyone should be sharing what we're talking about. But I think when you have the court hearing, everyone is tuned into that, right? Everyone's tuned into that court hearing. I just don't understand why, and I know what it is. Hank Brennan is the top dog. He's having people do things for him. Somebody tells him that this statement was made. Instead of sitting there and watching the Court TV interview himself, right, and seeing that it was part of a Zoom conference, or maybe he just went with the title. Karen Reed's attorney talks federal investigation.
Yes, yeah. I mean, but somebody on the team, either him or an underling that's feeding him information, has some splaining to do, because that should just never happen. I mean, it's unprofessional. I don't think he was intentionally trying to do it, because then he set himself up for this apology. Nobody wants to do that. I just think it was just sloppy, and he looks bad. It just looks bad.
So then right after that gets filed, right?
What else you got? I'll pull it up for you. What do you want? I got it. I got it all.
We have the gag order that gets filed by the judge. And I'm still reading page 6. I actually jumped to the end of the first and started going backwards, but I'm on my iPhone reading it like maybe all of you are. Okay. And what it does, it talks about, if you want to go to page 6, because it's an 8-page order. 8 pages.
Okay. Let me see.
I don't think I've seen anything 8 pages longer than 8 pages. There we go. What is it? Is that the ruling?
This is because remember there were sanctions involved as well.
Right.
And so it's a multifaceted decision. So we can just kind of cruise through it here to set up where we are and where we're going.
Okay.
So they're denying the motion for sanctions, which
thank goodness.
I think it's appropriate. Yeah, no sanctions. Remember, all of the hoopla was about information that was or wasn't provided when it was supposed to be, and things that were said, or in the case of Hank Brennan, things that maybe weren't said extrajudicially. And then the second half is about the gag order, and that came directly from the Commonwealth's request. Not their first request, but now one that's been granted.
Right, one that's been granted. And we went out the other day, and then it says although attorney Jack, and it talks about, actually, let me go backwards. It talks about the rules of professional conduct, right? It says, but then it goes after Alan Jackson. And remember I said to you that she had a thing about Alan Jackson the past couple of weeks, that to me that she was not happy with him for some reason, other reason, whatever it is, right? And she says, Although Attorney Jackson did not himself disclose information about grand jury proceedings to the reporter, that's Gretchen Voss, because apparently more of that was opened up today. More of the interview was opened up to support this gag order. He had 2 opportunities to intervene to prevent his client from disclosing such information. Instead, he sat idly by while his client disclosed to reporter the testimony given in grand jury proceedings. Well, you know what? The client wants to close it. You're not going to beat your client over the head. The client wants to close it. Go beat yourself up, and there you go.
Yeah, but she's saying, and I don't disagree entirely, that he has an obligation to correct her, prohibit her from saying more. The grand jury testimony is pretty critical stuff, and for him to sit there, if this is what happened, I'd have to look at it again. For him to sit there and just let her quote grand jury testimony and say nothing, I think that's a problem.
Well, it says
you should say something.
Additionally, during the interviews with both Voss and Fox 25 News, Attorney Jackson disparaged witnesses in the matter. In the Voss interview, and excuse me for my head's down, I'm reading this.
Yeah, and I've got it. I'm kind of tracking you with the document here.
In the Voss interview, he specifically referred to 2 witnesses as liars, right? He referred to 2 witnesses liars. Witnesses liars. They should be as liars. Okay, I guess it should say statements commenting on quote character, credibility, or reputation of the witnesses are more likely than not to have a material prejudicial effect on the proceedings, she says, and she quotes the canon of ethics. In the subsequent Fox 25 interview, Attorney Jackson claimed, 1, although individuals involved in the case knew what really happened, they are not talking. And 2, witnesses in the Albert home the night of January 28, 2022, had obtained lawyers for self-preservation, which implies that they are not being truthful in their statements to law enforcement about what occurred. Okay? Those are the 2 bad things, allegedly, Alan Jackson did. I mean, haven't we heard that all in the trial? I mean, my missing...
Well, I don't, we're talking about extrajudicial versus in the trial. Anything happening in the trial is protected and privileged and is irrelevant. These are statements made to the press. And just like I'm not going to suck up to Judge Bev when she screws up, I'm not going to suck up to the attorneys if I feel they've screwed up. These guys have been out there. Karen Reed can do all the interviews she wants, but when Alan Jackson's sitting right next to her, he has a certain responsibility. And whether or not he should be making comments about witnesses, you gotta err, and that's how you pronounce it. You gotta err on the side of not saying anything. And,
but then it goes on, and she has a footnote, by the way. Oh my goodness, there's a footnote. The court also notes that Attorney Jackson had a conversation with Voss at Omni Seaport Hotel, during which he revealed information that had been turned over by the Commonwealth in discovery, but not yet made public. In that discussion, Attorney Jackson acknowledged to the reporter that he was not permitted to disclose the information that he received in discovery, and he told her that she could not publicly disseminate the information until it was put in a court motion. Attorney Jackson then proposed a way to make the information public in an unrelated court hearing, as the reporter could put it in her article before publication. Well, I told you all yesterday, that's why attorneys file motions. Why do you think the Commonwealth files motions and puts things in? So that all this stuff can be made public.
Yeah. And I have no problem with that. I think the court's focusing on that is not really realistic in terms of the fact that it's done all the time.
Right.
So I don't think focusing on that helps her argument at all.
Well, but that's where we are. So by the fact that, and he said there was a previous motion, she didn't do a gag order then because no trial date had been set. But with trial now imminent, and with the above mentioned examples of improper statements made directly or indirectly by defense counsel, the court is no longer satisfied that the less restrictive alternative to the order previously given. The reminder to counsel they are bound by the ethical and procedural rules is sufficient to ensure a fair trial in this matter. The court finds that there is a substantial likelihood that the continued comments about witnesses and evidence in the case by counsel in the future might well taint the jury pool. Therefore, an order restricting such statements is now appropriate and necessary. And I'm going to let you go through the order about what can be said. But the problem I have here, Michael, the barn door is open. I mean, the barn door was open last year in the first trial. The barn door has been opened by all the bloggers. The barn door has been opened by all social media. The barn door has been opened by everyone. We're talking about all this. that we saw in the first trial that is public information. So now you want to issue a gag order? Come on.
Yeah, it's at this point it's useless. I would say that even if there hadn't been a first trial, because so much has been talked about in the case, and so many hearings have been held, and so many documents have been filed. So all it's going to really do is annoy me and others who might want to try and get a comment from the attorneys.
Yeah, but what I don't like here is she said Alan Jackson to get a pro hoc vice, right? And this is we had the motion for sanctions, and no sanctions have been issued, right? But what she's setting him up for is for somebody to file a bar association complaint against him. Now, to get the pro hoc vice, you had to show that you have a clean record, which he did. So now she set this up this could happen. So he's not going to be removed from the case. His pro hoc's not going to be taken away. So I guess she feels this is the least restrictive. But then you could do it in a different way. I've seen gag orders issued, right? But they don't then go after the attorney like she did, and that's what she did.
You mean she should have, in your opinion, just issued the gag order, not laid out these very specific reasons against, in most cases, Alan Jackson,
or put those under seal in case somebody wanted to take it up on appeal, right?
So that now, as we talk about this and others hear it and talk about it, it casts the shadow on the defense team.
Right. And yet we've had all the issues going with the discovery on the state that we've all seen. We have all the issues. We have Hank Brennan's mea culpa, and I'm going to accept it. If he says it was unintentional and was regrettable, I think what happened is, he was fed information by people working under him. He was doing other stuff. He didn't check it. He assumed it was right. And he has to fall on the sword for what other underlings may have done. I think, but he just, one in court and said it. So, you can't gag what happens in court. And I think I think what's happening here is the last 3 weeks, you've got this pull on the defense team when I don't think there should be. When you have jurors out there saying we found her not guilty of 2 charges, and yet the courts won't do anything. I just think it looks like it's fixed. I think it looks like it's one-sided. I think it looks bad, and I think it shouldn't have happened this way. That's my opinion.
You think the gag order doesn't do anything for the prosecution in terms of help or hurt them, but the defense gets hurt by the gag order, and
the client gets hurt by the gag order. More importantly,
well, she's not gagged though; she can talk.
Yeah, but she can. So if she says anything, I guess the thing to do is not have her attorney with her, so that way she can go and say anything she wants, and they, she can talk about anything. And what is the judge going to haul her into court? I mean, if your client wants to say something, let me tell you, if a client wants to say something, you're not going to prevent them from saying it. Okay, I can tell you that thing from being an attorney for all these years, a defense attorney. I remember it, and I'll give you a Bob Bianchi war story. In the middle of the Phil Spector case, and there was no gag order, right? There was no gag order, but you tell your client, try, and then at some point there was a gag order that was issued, but it didn't apply to the client's wife, because the client's wife always has the ability to speak whatever they want to speak. But, I remember waking up in the middle of trial to find out my client had spoken to a major Academy Award-winning reporter, also had done a movie in England, the BBC. And, he basically, Phil said, my life is in the hand of 12 people who couldn't get off jury duty. And waking up to that, I'm like, oh, dear. But he's right. He was kind of right. He was right what he's saying, because people try hard sometimes and they say the wrong thing. They're trying to go off jury duty and they can't do it, right? They haven't figured out how to do it. But so, if your client wants to talk to the media, they're going to talk to the media.
Yep. And a lot of that comes down to client control. But here you have a weird situation, because you have an attorney who has, if not promoted his client talking to the press, he certainly condoned it and been sitting right there, right? So it's tough to now say, well, let me put a lasso around my client to control that person from speaking out, when I've kind of been part of that process all along. So yeah,
but totally you're sitting there so the client doesn't say, I did it.
I did it. I hit him. I hit him. Oh, wait a minute, that already happened. So if you look at the order itself, it really just parrots a lot of the language from the code. None of the lawyers appearing in the case shall release or authorize the release of information about the proceeding that a reasonable person would expect to be disseminated by any means of public communication, if the lawyer knows, or reasonably should know, that it will have a substantial likelihood of materially prejudicing potential trial. I mean, there's so much you could argue about that stuff. but it's so broad and somewhat vague that it really handcuffs you. You know, you could be hauled in for saying very little and be told you violated the gag order.
Well, what if a juror from the first trial calls up? Let's give you a hypothetical. You know how in the A$AP Rocky case, John Lewin liked hypotheticals. Hypothetical, Michael Bryant. Okay. Juror number 47, who was on the jury, and I'm making this obviously hypothetical, calls you up and he said, I read all this that's happened to Karen Reed. We voted her not guilty. I want to go with that there. I want to continue to tell people her story. I want to do that. I want to tell people that I think the Alberts were lying. I want to tell people that I think this. I want to tell people that I think somebody else did it. I want to tell people that I think people lawyered up because they're guilty. I'm basically parroting what Judge Canoni says were improper statements, right? What does the attorney say? Do they thank you very much? Or if the attorney says, go ahead, you're free to talk, I just can't do it. Is that go ahead, you're free to talk, but I just can't do it? Is that a violation of the order?
Well, the way this is written, you could construe it that way. I would, if somebody asked me that and that played out like you suggest, I would say I really can't tell you one way or another. I wouldn't say anything. You're not going to stop them from saying it, but I'm sure not going to give them, my blessing, because that could be construed as a violation.
Yeah, but what if they call you because they don't want to do anything to hurt the client, because they think that the client is not guilty and didn't get a fair trial the first time around?
Well, yeah, but there's no way you could tell that person, make sure you don't say this or make sure you don't say that. If you're going to say anything, make sure it's this. I mean, you start doing that, you are violating the gag order. You're using this person as an instrument.
Even though the person may have had firsthand knowledge of the
sure, and they can tell anybody they want. Knock yourself out. But I, as the attorney who's now subject to the gag order, I ain't getting involved with you.
Well, if you say knock yourself out, but I can't tell you is knock yourself out violation.
Yeah, if you want to do what you want to do, it's a free country. It's free speech. First Amendment. You're not gagged. Take your shot. What do you think?
I don't know. I think it gets close, right?
I was talking to Domino.
Hi, Domino. Tubi's over here sleeping. So Tubi's like sleeping through this. So, just because I just find it so unfair to defense attorneys. Prosecutors have the ability for a long time to, lay out their case, right? And they indict, they bring people before the court. A lot of times there'll be bail hearings and all. And then as soon as defense says anything, oops, you violated the rules of professional conduct. Now, luckily I've never violated the rules of professional conduct, and I was very careful on the line because New Jersey is very strict. But I just think that doing this in public, here's my problem with it. Doing it in public has an effect on her that it shouldn't have. So you do it, I said that to you the other time, even on the if there was a motion. And you're asking for sanctions for a violation of the rules. The judge could have sealed it until after the trial. There's no prohibition on that. You can take things under seal as long as you're going to release them afterwards. Even this, say there's a gag order, say I'm putting my reasons under seal, and then release it afterwards, or release it to the court if they want to appeal the gag order. That's all. That's the problem I really have, I guess.
Well, I think it's a little too late to do it. That's my biggest problem. If you're going to do it, you probably should have done it. Hold on a second. Would you stop that?
Hi, Domino.
Domino's trying to turn the leather couch into a very comfy couch. It's not that kind of couch.
Yeah, but you see what happened? You tried to control your client, Domino.
I know. I have zero client control over Domino.
Domino said basically, F you, Michael Bryant. Okay.
Yes, and now he's
we know who rules the house.
Doing something else. Anyway, so I think the timeliness is ridiculous. And will it have any impact based on what's already out there? Probably zero impact.
All right, so before we go on to what else happened today, let me just go through a couple of questions. Lee Wilkie Donnelly, thank you, Lee. I've been following you all day. Thank you for your comments also on X Twitter. I'm waiting all day to hear your thoughts on today's filings. Well, you're getting them. And remember, we weren't supposed to be on the air tonight. We were going to run a show dealing with just comments, a pre-tape show dealing with comments. Should we tell them what really happened?
Yeah, I have no problem with that. We had it. It was a great show. It was probably the best show we've ever done. And last night I was late at night. I was getting ready for this little trial, and then I was also cleaning up some of our files because they start stacking up files for this show. And I was just deleting. and then I deleted the show that we pre-recorded. So
Oh, like
it was
hour and a
never
half.
going to make it to air, but as it turns out, it would not have anyway.
It
So
would not have anyway because we'd be here anyhow. So thank you very much. Sue says, question. How can Hank chatter in court and make accusations and never put in writing to make Bev make a record? Why wouldn't defense object to those? Well, we have the transcript. We know what he said on there. And, you know, and Yannetti was the one who got up. And if Yannetti hadn't got up and said, I must answer this, you know, and really also what happens is they went after the wrong person. Yannetti is the local guy, right? He has a lot of local street cred, should I say, right? And so when you go after him, who is a defense attorney, he's well thought of. The judge did let him get on and answer that, and that was a big whoops. That really.
well, yeah, and I think maybe even up to that point, Brennan had no clue. You know, he and it was like, oh shit.
Oh shit.
You know, because you know, no matter what you think of the guy, no attorney wants to be in that position where they have misrepresented something like that to the court. It's just, you know, especially if you are caught red-handed as he was. So
yeah. Now the grand jury testimony, I have to tell you, you know, we get that once we're going to trial. We have in New Jersey, for instance. Now you don't get it in federal court, but in New Jersey, we had a statute. Gosh, Bob Bianchi would know this. Probably 30 years ago, could have maybe even more than that. That said, if you make a motion for grand jury testimony, you don't get the deliberations. But if you make a motion for grand jury testimony, you get it. Especially if if testimony before the grand jury is of witnesses that are going to be at trial, because you want to cross-examine them. Now, some courts don't do that. I think Massachusetts is one of the ones that's very, very tight about that, and still goes to like the rules that occurred in 1777. You know, but you know, many of the forward-thinking states give you grand jury testimony. So once you're there, it's not really secret. Once there's been an indictment, it's not really secret anymore. You know?
Yeah. But you know, the grand jury testimony is kind of in that holier spot. You know, that if it could never, ever be released, that's the way they would prefer it. So I understand it's sensitive. I get it. Again, ultimate impact of this, other than the outrage that it's been put in place, probably almost zero.
Well, okay.
Domino agrees. So speaking of, you know, all the attorneys and now those that are gagged, one of them won't be gagged, right? Because he's not in the case based on. I'm telling you, this ruling came down so fast. I'm not sure the ink was dry on the supplemental affidavit from Mr. David Yannetti regarding Mark Bederow's entry into the case. And you got some hard copies there. Let me pull up the.
I have
the electric version here.
I had time to print these out. You know, still use my black ink on my printer to print out, because I do like to go through and all. And even though Missy was loading them, they were converting them to PDF and all, because they were coming fast and furious all of a sudden this afternoon. It was like
end of the week. I go, okay, I got some stuff on my desk I want to get rid of.
And quite frankly, after we got the motion on the gag order, I was saying, well, wait a second, what time is it? Is there time on the motion to dismiss? You know, because there was some supplemental affidavits in there. Yeah, so there was a supplemental motion for admission pro vice of Mark A. Bederow. Remember, he is Aidan Carney's attorney, Dr. Turtleboy, who, whether we have asked to come on the show, and we hope he comes on our show next week. You were in his hearing on his motion to dismiss in court in Canton this week. So we'll keep you apprised about that. We hope that it's going to be Monday, but we'll see what Aidan Carney's schedule is and whether he could do that. But we hope to bring him to you, and we will bring him to you in a fair and unbiased manner. As you know, we have no dog in this fight, except that me as a criminal defense attorney, I guess I got a criminal defense attorney dog fight, you know, maybe also as a prosecutor, because I was a prosecutor and I know what it's like to be a fair prosecutor. As I said, hand over your files. Here it is, you know, try the case. Yeah. No, so maybe that's old school. I don't know.
Oh, being fair and open. Oh yeah, that is crazy.
No,
so this was, remember what happened. Mark Bederow, who represents Turtleboy, Aidan Carney, he was offered by the defense team to take a seat. And so, as we know from Pro Hac Vice, and by the way, that's how it's spelled up there. If you've wondered, there it is. It looks like Pro Hac Vice. So the initial application was denied, which is unusual. And I did have that conversation on the street with Mr. Bederow to see what his thoughts were on that.
Right.
And so the court had some concerns. This
And
is
we've posted that on our Justice Serve TV channel.
And this is the supplemental motion for admission, meaning, okay, let's take another whack at this and see if we can, whatever the court's concerns are, let's see if we can address them. So this is from David Yannetti, has to come from him because he's the Massachusetts attorney effectively vouching for somebody from out of state, Mr. Bederow from New York. So he's in good standing, yes, blah, blah, blah. And I'm looking for the specifics that might have answered some of the court's concerns. And I'm really seeing that just the kind of normal stuff you would see. He's experienced, he has legal skills, has been at it since 1999, etc. This is what I think caused some issues, okay?
Right.
Paragraph 6. Prior to the filing...
How did I know you were going to go to paragraph 6?
Prior to the filing of the instant motion, Mr. Bederow conducted separate and extensive discussions with both Ms. Reed and Mr. Kearney. He defined and explained actual and possible conflicts of interest and the concept of waivable conflicts. He explained to Ms. Reed and Mr. Kearney the possible conflicts that could arise in his representation of both in separate matters that involve some of the same witnesses. He answered any questions either client asked. He reviewed rules 1.7, 1.8 of the Mass Rules of Professional Conduct with Ms. Reed and Mr. Kearney, and then presented both with copies of those rules. Mr. Bederow instructed both clients speak separately with their other existing counsel about these issues. Both clients discussed those issues outside of Mr. Bederow's presence. So,
with their own counsel, with separate counsel.
Yeah, and they both basically came back and said, "We're good. We're good. We can do this." So,
well, not only that, they said they acknowledged they understood the issues. This is paragraph 7. They confirmed that they wanted Bederow to represent them, even with the conflicts, and they executed written waivers, a written waiver to any possible conflicts of interest related to Bederow's representation of Ms. Reed and Mr. Kearney. So they just went, beyond that, right?
And compare this with the Donna Adelson case out of Florida, right? Which
Right.
had a false start. By the way, in case you've been under a rock for a while, her request to be released because she has too much earwax, that was denied. So she will still be in the jail annex there in the county, waiting for trial. Anyway, they didn't file the written waiver. That was, they came up to the first day of trial, and it's like, oh, where's the waiver? Because Charlie Adelson, her son, had the same attorney, lost at trial, and now she was going to take a whack at her case with him, but there was no executed waiver, so that didn't happen. So you have that here. Here's what I think, and the court references this in their decision. They go right to paragraph 8 after the unequivocal confirmation, yes, we're going to do this. If you go down further on the page, Mr. Bederow has never engaged in any conduct during his representation of Mr. Kearney, or anyone else for that matter, for the purposes of harassing or intimidating witnesses. That goes directly to the claims against Aiden. And Mr. Bederow will not share any protected material provided to him on Ms. Reed's case with Mr. Kearney or vice versa. That was huge with the court's ruling.
Right. And before that, though, they acknowledged that there never has been a joint defense privilege between Mr. Kearney and Ms. Reed. And what that is sometimes when defense attorneys are on the same side, when clients are on the same side, but they have different defense attorneys, they can enter into these joint defense agreements so that the privilege applies across for all of them. So if you have meetings and you're discussing privilege information, the privilege applies to both because they have a joint defense agreement.
And so that was the key, I think, to the court's ruling. They do mention in paragraph 10 that the Commonwealth didn't object, apparently, to the cross representation, but the court did. The court was most concerned about the potential conflict when you've got two ongoing cases that share some witnesses, share some facts, not the key facts, of course. One's a murder case, one is I don't know what the hell the other one is. These intimidating witnesses charges, as we've gone over ad nauseum, are a joke. But anyway, and so the court ruled. Let me pull that up just so we can go through the actual reasoning the court gave for denying.
And while you're pulling that up, let me answer a couple questions. Fat, dumb, and happy. I'm sure that you're not fat or dumb, but you're probably happy.
Hopefully happy, yeah.
And hope you're happy watching the show. And by the way, if you are, for all of you that are watching it right now, please hit that like button right now. I'm going to give you a second. Hit the like button. That gets us into the algorithm. Share, subscribe, and hit the notify. Hit that bell so you'll get notifications. It's all free. It's all free. We're not charging you anything to do that. But guys, that actually is not the full story. Judge Cannoni said in open court that she was fully prepared to admit Mark Bederow until Hank Brennan stood up and told Judge Cannoni that he had, quote, concerns.
Were they grave concerns?
I
Or
don't
were
know.
they just regular garden variety concerns?
Regular garden variety. And Jam also asked, why do they have to file a motion to add an attorney? Isn't that up to the defendant? Well, first of all, let me do it backwards before Michael goes to the ruling. You have to, this is a pro hoc vice. He is a New York attorney, so he has to be admitted just like Alan Jackson was and just like Mr. Leslie was, pro hoc vice by the court. So they filed that motion. Okay, so I'm turning it back to you.
Yeah, now I'm looking for that document because I'm not sure I'm not sure I loaded that one up. I apologize. Let me take a look. There's sanctions. Oh, there it is, right there. Hold on, I got it. The dog's driving me crazy because I think there's a burglar outside or something. Okay, hold on. Let me bring this up. And again, this was hot off the press too. I'm telling you, the ink was barely dry on that supplemental declaration.
Well, we got this.
Or affidavit, as they call it.
Right.
I call them a declaration. That's Californian law.
When I looked at it, I thought that was pretty good, because remember I told you the other day in New Jersey, you can't waive a conflict in a criminal case.
That's true. Yeah. Yep. And obviously they tried here and denied. So, okay, here we go. This is the decision and order on defendant supplemental motion. And not a lot to say. Obviously, cites the rules of professional responsibility and then says, apparently, speaking through Mr. Yannetti, Bederow promises to restrict his use of certain information. The clear inference of the promise is that Mr. Bederow would not use protected information gained in the representation of one client for purposes of his representation of the other. He thus proposes to ignore information known to him through his representation of one client, even where the information might benefit his second client. The court cannot permit such conflicted representation and declines. So, what do you think of that?
So well, I come from, as I told you, a state that wouldn't allow
it's not an issue then. You don't have to deal with it.
I don't know how to deal with it, but I have seen a federal court, and this in some way may protect Mr. Bederow from an inadvertent something or other. There was an attorney out in California who I got to know when I was out in the Spectre case, and he had some drug dealing clients in maybe in California, but he also had them in New York, and he somehow shared information between what he got in discovery in the two federal cases, and that was a big no-no, and he actually was disbarred for that situation. Oh, I see that my dog 2B is now barking at.
I'm trying to time my mute so
is Libby. Libby's 33 dogs are also barking. Disney nerd.
This is the when you know your dog, different barks, right? There's the bark that I want some food, and there's the bark that I want to go out. This is the bark that I see something outside that I would like to take part in,
And this is my dog is barking because he's hearing your dog barking. Tubi was. Tubi, listen to that. He's going crazy.
For a minute and calm him down.
Yeah, that's okay. So Domino and Tubi are okay. So a Disney nerd 85 asked, with this clear in the open bias the judge is showing, is there any repercussions that can be taken for judicial misconduct? No, because under the rules, she's not showing bias. We're talking about things, and she's well thought of. Remember, she's ahead of the committee to change the rules. She's teaching at Harvard. We're in the same group that I'm teaching at, the Trial Advocacy Workshop. And the issue becomes is not so much of whether what she's doing is wrong on the rulings, because Michael Bryan kind of agrees with her on the gag order and all.
Based on the very specific things she cited, I think were a mistake on the part of the defense. You're asking for trouble when you sit down and have a lengthy interview and you as the attorney offer opinions, in this case about witnesses, or you don't prevent your client from disclosing grand jury information. And
then on the pro hoc vice, as I said, I come from a situation that, look, keep me out of trouble. Make the rules so hard in New Jersey that if I follow them, I don't violate any ethical rules.
They're protecting you from yourself in New Jersey.
And I think the problem that I have is that to do some of this in open court, even though we have a reason for open courts, but you could, for a good reason, file things under seal. And I have that problem to do it because you have a trial so close that doesn't that infect the jury pool? Maybe not purposely at all, but it affects the jury pool, I think. And I think that's a disservice to the client. I think the court has to be mindful of the fact that the court's there to protect the client. And while this may not have been the intention of what happened, I think this is exactly what has happened.
Yeah, and this, this case is obviously very different, not just because there was already a trial, but it's a Mars kind of case. Everybody on the planet knows about this case. So unless you come from Mars, you have some exposure, one way or the other, to the case. Here's your friend Leah saying that they already tried. Oh, it disappeared. Why does that always happen?
I know.
They already tried to indict Karen Reed and Turtle Boy for allegedly conspiring to intimidate witnesses. Yeah, they're still working on that. But the grand jury refused to indict due to lack of evidence. What conflict could there be? Well, the conflict has to do with the attorneys. You can only really, I've always felt, represent one client, okay, period. 100% one client. So if you have another client that might have disparate interests because the cases do overlap, and there are some, the issues in the murder case are not the issues in the witness intimidation case. So you can't put either client in the position where the information you have on client one can hurt you with client two, or vice versa. So it's not so much about what the law enforcement or the prosecution has tried to do to the two different clients. It's what you know and how that information could bleed over into one client or the other and hurt those clients.
But I think what Leah's saying is that they do everything, like they're going to take that to grand jury. And instead of just trying the cases, you talk about intimidation. If you think everything that's going to happen is going to be taken to grand jury, isn't that an intimidation of you exercising your constitutional rights? I mean, that's...
sure. I mean, that's not a conflict of interest issue, though. That's a totally different issue. Have you seen the video of Aiden that night at the pizza joint?
Yes, I saw it. Was released.
And
on Twitter.
That's my friend behind him who's helping out, and I don't know if he's probably talked about who he is, but not knowing whether he has or not, I'm not going to rat him out. But I think what was done that night was looked at as, and I would tell this to Aiden, to his face, it's childish and probably not the smartest thing and goofy and, but is it criminal? I don't think so.
It looks stupid. It looked like it was stupid. It looked like two kids doing.
Yeah. Well,
things, right?
Perhaps some adult beverages were involved. I don't know.
Mm-hmm. But to say it's criminal, come on.
Yeah. Again, if you look at the list of the current 16 charges, and now what it looks like is going to be the 17th, none of them strike you as being, a problem.
We have a group of two dogs here, and apparently there's another one, right, Livy? They're barking at each other. Yes, they're. Maybe they just want to be on TV. Maybe they want to be on TV.
Yeah. Well, I know one that's going to be on timeout pretty soon. Who knows what's out? It could be, out here, there could be a raccoon out there. It could be a deer. Who knows what's going on?
Yeah. We've been there. So that was, and if you think this is enough that's went on today, and by the way, let's say hello to some of the people that are on here, because you've been on here, you were waiting for it. Oasis Cat, hi. Thank you, such a big
Shy Gal.
Shy Gal, thank you. I know we're working something out. Kay Schmidt, hi. Thank you, Kay. Thank you for being on here. Jam to me, Mr. Brennan.
Jason's always in here. Jason Hodges. Yeah.
Jason Hodges is always in here. There's so many people. I mean, I almost can't go down the list. I'm going to lose my place here in terms of questions. But boy, thank you very much. You're all chatting away. A respected officer, Queen. I don't know if I've seen it. Is this your first time watching us here? Let me.
What's the name? I didn't see that one. Respected.
Let me show this. It's a question that I haven't seen you before. Why are the FBI investigations and other things that have happened, like the grand jury to be mentioned, isn't that in the interest of transparency? I agree with you. I said to Michael Bryant, we were talking sometimes, we talk by text. Are we ever going to see the light of day of that federal investigation? Probably not. Probably not, right?
Probably not. No.
Probably not. And you can't even get, if somebody testified for a grand jury, you probably can't get their testimony to be able to impeach anything, because you have to first show that they testified in a way that you can use it as impeachment. And how can you use it as impeachment if you don't know what it is?
Yep. Yep. It's a very interesting catch-22.
Yeah.
Thank you for not eating my microphone.
Just gifted JSTV.
Oh, thank you. That's nice.
Memberships. Thank you so very much. Really appreciate it. Allegedly, maybe. Thank you for joining us. Making a count. Thank you for joining us. Cashman again. Yes, it's scary. It certainly is. But thank you all. In case I missed you, it's not
Dr.
because-
Hasso. It's a name I haven't seen before. Have you seen that?
No,
Dr.
thank you.
Hasso, welcome. Bev is doing this because of all the pushback she's receiving from the KR team. She's retaliating. And, you know, that could be a motivation. There's no doubt about it. She's certainly facing, in this case, more than she's normally facing from a defense team. Would you agree with that?
I agree. Hi, Kale. Nice for you to join us too.
But
Maybe
that's, you know, this is an adversarial process. That's the way
Right.
it should be. You're not in it to make friends. You
Well, I
you're in
know-
it to represent your client.
you're in it to represent your client. I remember when we were doing Aaron Hernandez, the judge who we liked a lot, he castigated one of the members of the team in front of the jury. And when he left, we got up and we never again in front of the jury. You want to yell at us? You want to say we do something wrong? You yell at us, but do not affect my client in front of that jury, okay? And you know the judge backed down. The judge actually came back and gave the jury an instruction.
An instruction
I'm
saying what I
sorry,
say is not.
counsel did nothing wrong. I may have overreacted. What I say is, please don't, blame me. Don't blame them. They're doing a great job. You know?
Yeah.
But you have to be willing to go at a judge if you're a defense attorney.
Yeah, exactly. You got to go John Lewin on them occasionally.
You got to go John Lewin.
Yeah.
Oh, you're gonna make his name into a meme. First we have Lou Weiner, then you're gonna go John Lewin on him.
Yeah, just don't be a crybaby.
Yeah.
Don't do that.
Oh no, I what's coming? Oh, what's coming?
No, I don't have it. I don't have it handy. I've got it in my file for him and for ASAP. I may have to pull that out and be able to use it multiple cases.
Yeah.
Okay, so what should we talk about the?
But I do. But first, I want to talk about Nem and what she said. She's usually lurking, but this dog was too cute.
See, so Domino pays off again.
Okay, I'm turning it back over to you.
So we've heard so much about these Sally Port videos, and my brain is mush now trying to figure out which ones came about when and where, and which ones have the gap in them, 42 minutes, and which ones are inverted, and which ones are too blurry to be useful. So they made an effort to clear that up, right, by providing further information. Domino,
Tubi,
come here, come here.
Oh, Tubi the poodle. Oh, Tubi the poodle. If I could pick you up and go get you, I would pick you up, but go get you. But I'm tethered into my computer with earphones and all sorts of stuff.
Okay, so interesting. Folks have looked at some of those documents and I guess revised Sally Port images, and there seems to be some concern. Remember, one of the issues was, hey, how come that one video was inverted? And the prosecution has suggested, well, it's always been that way.
Right.
The camera's always been just screwed up, and we ultimately replaced it. So they provided imagery and video from prior to January 29, 2022, that the early morning hours when the car was brought in there. Well, did they find something kind of wacky about that? Did they learn something that made it look a little off?
Yeah, but you know what? I think you have to look at those because what may have been looked a little off is mentioned in another filing that we have before our trusty
Well, let's
people,
see if I have that one handy
our
here.
trusty people on X because really did their own investigation work. There was a supplemental exhibit in support of defendant Karen Reed's motion to dismiss for extraordinary government misconduct. And you may have it. I actually took it off X Twitter, and I don't know who I took it off from because it had already had yellow around it and whoever did yeoman's work. And I apologize if that's the one we have and I can't show you.
Yeah, the one I've got actually has some pink writing on it, and I believe that was from somebody, Olivia Lambeau.
Okay, so that's
which
different.
Which we will get to. I'm trying to find the document you were talking about, though, which is
because it mentions Exhibit 5, which are the screenshots that you want to look at, that you want to show.
Here you go. Let's see if I can pull that over here for you. Okay. Now I'm worried that the dog is not barking.
Uh-oh. I know there was a question here, too, that Leah would it still have been considered conflict if they had a joint defense agreement? Interesting question.
Would it still have been considered?
Yeah, interesting
Oh,
question. There's two
I think
separate
so. I'm
cases.
going to
I
say
think
yes.
so, yeah.
I'm going to
I'm
say
gonna,
yes.
I'm going to say yes because it's two separate cases.
Yeah, and still
yeah.
the potential is there, and that's what the court is at least supposedly concerned about. Okay, so here it is. This is the different exhibits. Let's see where it starts here. This is the supplemental exhibits in support of defendant Karen Reed's motion to dismiss for extraordinary governmental misconduct. As a way of a little bit of backstory here, remember, this fully throated motion was on calendar. And the defense, Alan Jackson, said, well, wait a minute, we keep getting new stuff. So we want to move that date from Tuesday the 4th, as it just happened, to sometime the week of the 17th or sometime later, right on the verge of trial. And the court said no. So when he made his arguments, when Jackson made his arguments, he told the court, I may want to provide supplemental material for this motion based on the new stuff we got from the prosecution. And that's what this is.
Right. I think there were 9 more videos, and there were 15 videos of them taking down the videos or vice versa. And so that's why he came back and argued it Wednesday. And so here it is.
So all of these exhibits were attached, and they include, like Exhibit 2, photograph of condition of right tail light in the garage February 1st, after Trooper Proctor and others at the Canton Police Department had access to the vehicle taillight. Then you see it totally damaged, right? Not just cracked. And then you can see I like Exhibit 4, 47 pieces of plastic. I keep getting that number confused because it seems to grow all the time.
Which is why when we posted a picture, I posted it actually, of you holding one of the pieces of plastic from our exemplar. I said, they're coming to take you away, Michael.
I know.
Because now you have 48.
Now when we started covering this with Law and Crime, I began making fun of this then. It's so comical that they would continue to find these pieces over the course of days and weeks after the fact. That I just happen to find them. I don't know how. Here's my bag. I've been collecting them, and they just seem to materialize. I thought I had one in my my cup of not coffee. Yeah. So yeah,
I knew this was going to be such a show that I ran and I found out I didn't have any Dunkin', so I had to quickly order from DoorDash my Dunkin' Donuts.
Oh my gosh! I think you have perhaps something you
swimming
need
pool.
to break that. That sounds like an obsession bordering on addiction. Okay, so
I crack cocaine, my mango tea.
That's okay, so the photographs of the 47 pieces, that's all wonderful, but the screenshots of the interior Sally Port back wall camera, that's the fun that they're using, and we want to look at some of these pictures here. Remember, why is it inverted? I don't know. It's always been inverted. The whole thing has been inverted. So here's some imagery from prior to, like, let me pull this one up. This one is from January 1st. Okay, January 1st. Hold on, and this will be of the famous. You'll recognize the scene. It's the inverted imagery, but we'll look at the date and we'll look at why the defense thinks we got some splaining to do here, prosecution. Okay, so, and again, these annotations are thanks to Olivia Lambeau. She did, I was kind of busy today, so she did some work for us inadvertently. I don't like to steal other people's stuff. I want to give them the full.
We want to credit it whenever
credit.
we can. Yeah, right.
Yes. So here it is, and what she or he, Olivia, I don't take anything for granted. What the person is saying is, you can see down here at the bottom these icons which are used for various
I'm just going to hide this
software
comment for a second.
programs.
Yeah, I'm going to hide
Adobe.
this
What are you doing?
I'm hiding the comment, the question we're going to answer for.
Oh, okay. Adobe
this.
Photoshop. Let me see if I can pull it up a little bit to make it a little easier to read. Maybe not. Let's see. See if I can get a little more room up to the top. That's as far as I can go. So Adobe Premiere, Adobe Photoshop, and this one I'm not familiar with. Aegis Sub. Anyway, these are all programs that if you choose to, you can manipulate the video or the graphic or in this case, we're looking at the time code. So here's the time code. And again, the date 1/1/2022. So roughly a month before the subject images were taken. So you got yellow text there, right? See that?
Right, I see that.
Now yellow text. So that will become interesting because let me move to the one that we're more familiar with. from, this is from 129. I need to get, can I get a, what's his name again? Kokomo? I need a Kokomo from YSL.
Kokomo.
Mr. Kokomo, please,
Kokomo.
would you put that up for me, please?
Yeah. So that was the one we saw, the wall. That was on 1/1/2022.
Yes, that's 1/1 and
Series
had
salary
the
report,
yellow.
back wall. Right.
Yep, has the yellow. So I'm going to find for you here the one that is, I believe this is the right one. We'll find out soon enough. This is from the date, the subject date, and this is still from basically all of the video that was. Come on, help me out here. There we go. Okay, so this one, again, I'm trying to, maybe I can shrink it down. Yeah, there we go. So we can better see the very bottom of it. This has a date. You may not be able to see it, but trust me, where I'm circling there, it says 1/29/2022. What color is that imprint?
Blue.
Yeah, it's not yellow.
No.
Now, I can't understand why, without some sort of manipulation, it would have a different color on it. What kind of camera would just have randomly different text color, from one date to the next? That seems rather weird. And here's where, even though that is properly, left to right, good old, American English, look at right here on the cop car. You can see the word police. The rest is kind of covered by stuff.
Right.
But it's clearly backwards, which made it so easy to determine this was inverted. And I have a feeling that the pros and all the law enforcement never noticed that, never had a clue. And when they did, they weren't saying a word until Alan Jackson caught them on cross-examination. So that's the question. What is it? What do you think that means? Obviously, the defense thinks it reinforces that the prosecution has manipulated this video.
Right. I mean, I don't know what the explanation is. I mean, there's going to have to be an explanation, but that's the problem with this case. There's so many things that need explaining, right? There's so many things that need explaining. This is a case that does a disservice to the justice system. It does a disservice to John O'Keefe. If he was killed, and it does a disservice to Karen Reed if she's wrongfully accused, right? All of this does a disservice to everything that we're trying to do in a court system with a court case. Everything.
Yep.
So while we look at before you look at the next pictures, Jan asked, why is it okay for the prosecution to show inaccurate photos? I thought, all right, I had the same reaction.
What you do is, let's say, this hasn't been seen by anybody, and so you're bringing it to court and you're trying to lay a foundation for it before you enter it into evidence, or even use it as a demonstrative exhibit. And of course, the difference is the jury is not to rely on demonstrative exhibits, and they won't go back to the jury room with them, but they're to help them understand something. No matter what, it has to have some foundation. So you have to call somebody in to say, yeah, this was from this camera. These are routinely captured images. We keep them in the normal course and scope of our work. And there you go. So if that's enough to lay the foundation and it comes in, it's up to the defense then to start tearing it apart and say, well, as Alan Jackson did, what about the backwards letters? And now I guarantee you, if these two images come in, and I can see no reason that they don't, right? The one from 1/1/2022 versus 1/29/2022, then you're just going to be grilling whomever lays the foundation. Well, why is the text color different?
But then you're getting back to the issue that we talked about with Richard Glossop. If you have an officer up there and is laying the foundation that these are accurate portrayals of the images as they were taken off the camera, an accurate portrayal of how the camera records them with the wording and the color, how can that possibly be? How can you have somebody do that?
Okay, well, let's break this down further. Maybe they're attesting to the image, right? It's not like the images, but we're talking about the specifics of the printout of the text on the bottom.
Right.
So are we going to have somebody that's going to be able to testify that yes, I'm the one who normally records these things and catalogs them, and it's always been that way, and it's the color seems to vary without reason. I can't wait to hear the explanation for that.
And then here's what Alan Jackson in defense is going to say. The camera that recorded the clearest images, because we know the ones outside and inside were all blurry, but the camera that did record the clearest images, even though it was inverted, remarkably, the Commonwealth thought they had to get rid of it because somehow it wasn't working properly. So, so they're going to say, well, it wasn't working properly because it was doing things in different colors, right? I mean,
Yeah,
that's what's
I
coming,
hate
right?
when that happens, when my camera prints different color graph on the bottom. Yeah,
So
that,
how does that, if you don't have the camera anymore, the defense can now check it because the camera is gone. How
mhm.
does, you're putting the defense at a disadvantage
Yeah,
because you're
and
going to
of
say the
course,
camera.
it makes the prosecution look shifty and shaky and like liars. So there is some benefit to it, but who knows what the jury's going to do with that? Who
Right,
knows?
right.
You don't want that even to be in their decision-making process if you can't lay the foundation for it. So
Yeah.
we'll
And
see. I think they're all coming in. I
I
think
think they're all coming in too, and and it's going to be up to the jury. But then, the chyron being different colors, he talks about it has a different colored chyron than 12922 inverted video produced defense on April 4th, 2024 from the same camera. The discrepancy suggests manipulation and further underscores the prejudice to misread by the Commonwealth's destruction of original files and metadata associated with the download of the video surveillance footage from Canon. I don't see, in a normal case, if you or I, if for instance, you've had 3 trials in the past 2 weeks, you want to bring something in, you have to show that it's true and accurate, right? And you have to show a chain of custody.
Yeah.
Chain of custodies don't, people always say, oh, chain of custody is so boring. But there's a reason for it to make sure that what the jury is seeing is true and accurate. How does this all come in? And remember, Alan Jackson said he doesn't want it excluded. One of the remedies
Yeah,
is
of course.
exclusion. He wants it
So
in.
so you don't want to, when they lay the foundation for both of these, the blue, I'll call the blue, and the yellow, I'm not objecting to their entry into evidence. Bring them in, because then I'm going after the people to point out to this jury something ain't right here. Somebody's manipulated these. Why would they do that? Because they're lying, because they're covering something up, and you're not getting the real story.
Right. A respected officer, Queen asks, and let me just put this up if I can. And thank you, Ms. C, for starring these. I appreciate it. Can the defense use Hank Brennan's lies from the hearings as evidence? You can't. You can't say what the prosecutor said in a hearing is evidence. All right. We try to do it all the time. As a matter of fact, a lot of times you try. Sometimes when you see the DA or a prosecutor make a public statement and say something to the press, and you try to subpoena that as evidence that it is exculpatory to your client or something to that effect, the court say, hands off, that ain't happening. So the answer to that is no.
Yep.
Allegedly, maybe, how can it not be manipulated? Oh, here's let's see. One picture the garage door. Well, one picture the garage door was open, and one picture it's closed, and therefore, what you're really seeing is how the camera perceived the writing, and the writing may change, just like because there's some kind of, I don't know.
Okay, here's my explanation. I can't wait to see if this is what happens. So they bring the custodian in, somebody that has been routinely involved with playing with the camera, setting the camera, because you can go in, obviously, and when you buy one of these cameras, they don't automatically have the right date and time on them. You go in and you fix that. Well, you also can go in and fix the color. So they decide at some point in that 1 month that the blue is easier to see. I think that's wrong. I think the blue is harder to see. But they purposely changed the color from yellow to blue because it became easier for them to read. And I'm the person who changed that color. That's all there is to it. That's it.
That's all I can say. Yeah.
You're not buying it.
I don't buy. In fact, I'm happy he says suborning perjury. Well, except that prosecutors will say, as John Lewin did in A$AP Rocky, I'm not vouching for my witnesses because you're not supposed to vouch for your witness. So that's the one thing. Like in trial, you're not supposed to say, I know him personally, or I know her personally, or I know them personally. They're just great, honest people. You're not vouching for it. But certainly when you put up your witnesses, you have to believe they're telling the truth, right? I mean, it's just I'm at a loss for words. We have a lot of questions coming in on this. By the way, let me just stop you all. You have almost 200 people here watching, a bunch of you chatting. Please hit that like button. I only see 81 likes. Come on. If you hate us, even hit the unlike button. As Afton Farrad said, Zafton always says, even that gets us into the algorithm. But if you can, just take a moment, hit that like button, the share, the subscribe. It's free. We're free unless you become a member, and there's going to be some benefits to that.
Yeah, then you get like that great video I posted today walking the dog. A
No,
respected
no, I never heard
officer's
him with it.
queen. Well, I was talking about something
Yeah,
important.
yeah.
What about the editing software he showed to the judge? Does she have to pretend she didn't see that? I think we're talking about, there was a glitch in, or a pop-up
Right,
when, and I thought that was just a pop-up that we would all get when you're using certain software and it's an ad, right?
right,
I don't know that that was as nefarious as people want it to be.
right. I agree with you on that. And I call it out when I see it. I don't think that was, because I get it all the time. I get
Oh
it.
yeah, it's just
I
so
get them
annoying.
all. As soon as I get on Adobe, I get it. Oh, try this and try it. It just pops up. Like you're gonna go buy it right then and there.
Okay.
So yeah.
Maria Santos says, another point, the other camera couldn't produce any legible video, but the only camera replaced was the inverted. I know, the only camera with a decent image is the inverted camera. The others, they should be replaced. If
Right,
they're
right.
truly that blurry and that useless, why do you have them? I would be very curious to know if they've replaced those other cameras. You say you've replaced the inverted video camera. How about these others with the blurry, unusable, crappy images? Have you replaced those?
Apparently no. Apparently I don't think they did. I don't think they said that.
Why wouldn't you
Just
do
the
that?
one, because Alan Jackson said just that one camera. The one that the only one that's replaced is the one that actually recorded clearer, even though it was inverted, to make it count. Michael, can defense get a camera application software expert like they did in Amber Heard case, where she manipulated many photos? But what about the metadata here? There's drag and drop.
Yeah. Well,
What does that do?
I guess it drags and drops the metadata behind, right?
Right. You don't get the
come with it.
metadata. Right. And they don't get the metadata.
Yeah,
And
I think sometimes it's easy to go down the rabbit hole about what about we do this. Just common sense will tell you. You look at those two images that are being presented to show that, oh, whoopsie, the video is always inverted. It begs the question, well, why is this other stuff changed?
Yeah. Yeah, it's absolutely a lot of questions going on here. While we're answering them, please hit that like button. Loca asks, what about all the other motions from Commonwealth and defense? This case might not even start. No, it's starting.
Oh, it's starting, baby.
It's starting.
It
They can file a motion to, I don't know, I can't think of what else they could file, but no matter what, if she's starting this case April 1st, come hell or high water, barring an upper court getting involved for some really serious reason.
Yeah.
This case is starting now. It may very well be that if I'm the defense, I wouldn't make a motion that all these things being done in open court inures to the detriment of my client. But the answer to that will be, well, we're gonna voir dire the jury. We're gonna make sure you have a fair. If you've heard anything about this, and all, and the case will go on no matter what.
And then it's always, this is going to be a tricky case for weeding out the folks who want to be on the jury.
For the prosecution and for the defense, right?
Well, for everybody, yeah. There will be people that want to be on this jury, and you don't want them on your jury.
Right. Anyone who wants to be on a jury, you don't want them on.
No, you don't.
Maggie Reyes, Linda, Michael, have you all seen all the things leading up to the first trial, like the pre-trials?
We saw everything there was far fewer activities pre-first trial than we've seen now pre-second trial, but I think we saw everything that if you get more specific there, Maggie, we can respond. But I recall seeing most everything when we were at Law and Crime at the time.
Yeah, and the problem you have is that all that gets washed away. All these rulings that you have in the first trial, unless they carry over to the second trial, they all get washed away. That's
speaking of that, and the motions in limine, which we think the deadline was for yesterday, nothing's been posted, so it's possible they're keeping those off the public record. Maybe till next week. I don't know. Maybe
it's there is. All of a sudden we're going to do things in secret. Maria Santos, another point.
We just did that one. Yeah.
The other cameras couldn't produce any legible video, but the only camera replaced was the inverted one. Yep, that's the way you just said. Michael said before. Yep. Amazing how that happens in cases. Just amazing. Let me just unstar that here. Alert One Systems. Where is the bad camera? It's gone. As a matter of fact, I don't even think until the hearings the other day, I don't think anybody knew that camera had been replaced from the defense. It sounded to me like that came as a surprise.
Yeah, I think you're right. I think it came as an explanation. I'm not so sure that the proof that it was replaced has been really verified. Somebody said it was replaced, but okay, can we get the person in here who replaced it? Who is that? Is it an independent third party? I doubt that the police department has their own in-house, IT guy that is doing cameras and stuff. They had to bring in a third-party vendor to do that. I want to talk to that person.
Yeah, and I think how we learned it. If you recall, Hank Brennan got up there and said, "Look, when I was hired to be in this case, and I took on the responsibility to represent the Commonwealth of the state of Massachusetts, I started doing my own independent investigation about why we have all these dribs and drabs. Because the judge did say, why are you having all these dribs and drabs of the cameras being out? And of course, nothing is clear. But first we're told that the camera footage doesn't exist. Then we're getting dribs and drabs. Then we're told it does exist. Then we're told it's on a detective drive. We don't know what detective. And then we're told that then we're told it's gone after 30 days. And then we're told there's a backup system, which we don't know, but that the backup system was taken and put on a jump drive, and that's by some retired detective.
Retired sergeant, yeah.
Retired sergeant. And then we're told, by the way, where was it found? And then we're told, by the way, it was done immediately, even though the Commonwealth said nothing was asked for it to be held, and it really wasn't germane or important to this case. And then we're told that the USB that had all this, even though it didn't have the metadata and the clear original videos, was found in the detective file. But which detective was it, Michael?
That darn Proctor factor. So, they dumped on him saying he knew he had everything, but whoops, never told the prosecution.
So that's how that all came out. If you remember.
And I just noticed that Disney Nerd told us that they moved the deadline for the motions in limine to Monday. So those should be interesting reading.
Okay, those would really be interesting reading, because some of the stuff you're going to hear about motions to dismiss based on some stuff, you still may have some motions.
Yep. Okay. And remember, this was a filing in supplement to the motion. Now this is fully throated with this supplemental material. There's no decision on that yet. Now, I think we could agree it's probably just a matter of her saying no thanks and giving them the time to make this supplemental argument. That means most of this stuff's going to become motion in limine.
Or does Hank Brennan get a chance to respond, as I think maybe he does, to the supplemental exhibits in support of the defendant?
Well, good. Then he can tell us why the Chiron is a different color.
Yeah, and then she decides that afterwards. Touche. Do you think Karen Reed would be and would have been better off if the Turtle Boy stuff wasn't going on? Michael.
That's interesting. It is an interesting diversion. I'm not so sure it hurts her, though. I think if you believe that the prosecution is wrongfully going after Aiden, then it just supports the defense argument that they're going after Karen. So I think it's not a bad thing for her.
Yeah. Now our chat's really going on here. It's 152 people chatting. Again, hit that like button. Please, you're chatting. Hit that like button right now. Let me see. I mean, I can see. Missy can actually see better than I can. People going up. And if you have other questions, I see another question, because this is your time. Michael and I we spent an hour and a half last night taping an episode where we had.
Okay, don't rub it in.
No, it turns out
here's how it went. Bye-bye.
No. This is a compliment. We had answered all these questions that you had. But I think most of those questions actually ended up being answered today.
There were a lot of them were about this video and all the issues with the video.
Right. So if we haven't, put back in here, because I can see a couple of them. Avid events, and I'm just going to throw one in here. Do you think any of this is the Commonwealth strategy not to retry the case and get it thrown out due to CPD and Michael Proctor, and then still claim Karen Reed is guilty? That was one of the ones that we answered last night that has not been asked.
What was it again? Sorry.
I'm sorry. Avid events. Do you think any of this, all this stuff that's going on, do you think any of this is a Commonwealth strategy to not retry the case and get it thrown out due to Michael Proctor and other stuff that's going on, basically? Then still claim Karen Reed is guilty?
No, not a chance in hell. They want this case to go to trial. They've had many opportunities to take an off ramp. Even if remember the motions that were filed based on the jurors saying counts 1 and 3 were decided unanimously. Even if that went nowhere, as we know it did at the appellate level, it still is a slap in the face to the prosecution, right?
Right.
And it should get them to take a step back and go, whoa, we were barely clinging to life on one of the 3 charges. Maybe we should rethink the prosecution. Did they do that? No. They just doubled down. So, yeah, I don't think they're looking for any reason to do anything but forge ahead here.
Right. Livy 33. Sorry if this has been asked. Do you think Judge Bev will put on the record in court that Hank Brennan has misspoke again about the defense attorney in an interview, but it was actually in the court Zoom?
Nope. She has no reason to. The documents speak for themselves, and unless she's going to do something against him, and she then has to say, well, here I'm going to admonish you, sanction you. Certainly nothing that's going to happen in open court during the trial. I don't think she'll do anything.
Except, you know what? She may not. But if there's going to be arguments in court on the motions in limine, I would imagine that in some way, Alan Jackson will be able to get in. And we've heard this representation from the prosecutor before. We heard them represent. We didn't give the stuff on ARCA.
I could definitely see.
Represent that we did.
I could definitely see the defense using it. I just don't see the judge doing anything. Like bad prosecutor, bad boy. I don't see that happening.
No.
I'm sorry, Domino's got twitchy if I say that.
Yeah, Toby just looked at his head like you were yelling at him.
Yeah, sorry.
Okay. Shy Gal. Hi, will Hank call Proctor? Oh, this is a discussion we've been having.
Man. Yeah, and we can't see it happening, but wouldn't it be fun? I mean, there's so many reasons not to, whether it's Fifth Amendment claims he might make or just the Pandora's box of ugly. I just can't see it. I do want to know, and I am curious to see how they work around the lead investigator. That's going to be very, very interesting.
Yeah, we'll see. And then if they do work around it, if the defense decides not to work around it, then we'll see. Right? Interesting. This is going to be a big one for them. That's going to be one of the decisions. We'll have to see what's being made. I think we'll get a handle of how Hank Brennan is going to try this case on that very decision that you're speaking about. And you know what? I think it also involves his lawyers right now, because remember, he has 2 days of hearings were there, or was it 3? 2 days of hearings as to discipline about whether or not he's going to be terminated.
Well, yeah, I know they had to, but I don't know if any decision was ever made or if there's another one on the calendar yet.
Well, what if he's terminated? Let me ask you this, because you have all those terrible texts, right? And you have all the terrible texts. And who was the officer? Was it Flannery? Who was the officer they said was a great officer? He was vouching for him.
Was that Fanning, the one that
Lieutenant Fanning, right?
Yeah, and he's the guy that allegedly has told at least one juror that that the other case that is not part of this case, but it is in nearby Stoughton, the Birchmore case, that she was not murdered.
Right. And he was vouching. Well, you're besmirching his reputation. But he also, I guess, the argument was that he didn't discipline, even though he was on some of the chain emails for those terrible emails said about Karen Reed and her bowel problems, right? That she has medical issues. The question was that he was just on the emails and all. But
Christine is a new member. She says, I feel Officer John O'Keefe is getting lost in all of this. And we've talked about that many, many times. I feel the Commonwealth is more focused on protecting the witnesses than actually finding the perpetrator of his demise. Well, if you believe those that think the prosecution has this master plan to not only frame and stick this on Karen Reed, then you're right. you're right. The real question is, are they just inept, or are they actually making a concerted effort to do this?
Yeah. Before we get to some of these questions, there's some of the questions that we answered last night that are still relevant. Afton Ford asked, is it Massachusetts law or Canoni standards that require an MD to testify as to wounds?
And shout out to Afton. She's one of my DIY buddies. When I do my updates on the bathroom renovation, she's right there pitching in. And I have another one coming up soon because we're making some progress there. Yeah. Anyway, we know now that Dr. Crosby, PhD Crosby, is being allowed to testify about the dog bite wounds, right?
Right.
Not an MD. And yet the defense had a witness denied because they weren't an MD, as I recall.
And the defense also had 2-day hearing on their
Dr. Russell got grilled for 2 days, poor lady. I thought she was going to, melt. But yeah, she appears in trial 1, then has to have a Lanigan hearing for 2 days before it is a close call, according to Judge Bev, and she's allowed to testify in the upcoming second trial. Whereas this guy Crosby, it's like, yeah, of course he's an expert. Of course he is.
She was grilled like you'd grill a mafioso, right?
I mean, it was clear, she's a doctor.
Mafioso, right?
She's an ER doc, and she'd rather go back and work in the ER than deal with what she had to go through in court.
Yeah, but thank you, Christine, for that question, because we talked about this. That the real thing should have been, I mean, this should be on John O'Keefe and what happened to him, whether it was a crime or not. What happened to him. And all, and finding truth and justice and all, and it seems to have morphed into a get Karen Reed at all costs, in my opinion. And maybe she is guilty, but the state has to prove it beyond a reasonable doubt. I don't know the answer.
Yeah, that's again, I don't want the case to end for the prosecution with what the hell happened is my takeaway. That's not a good thing. Thank you, Kay Schmidt.
For the 5 memberships that you gifted. Yes, right. Oh my gosh, 5 memberships. That's fabulous.
I think that's very nice. Yeah.
Shy Gull asked whether or not AJ Alan Jackson can call Proctor. Yeah, we talked about that. It depends on, he could possibly. He'd be an adversarial witness. I mean, you get him right away. I don't think you hostile witness. I don't think there's anything out.
Yeah.
But then there's also other issues about what are you going to ask him, because he's going to try to, get out of everything, right? Maybe you can get that evidence in about how he was, other people were getting these texts from him, and
get the other side of the text. And they were mostly, I'm trying to remember, was it Tully or who was on the receiving end of most of that stuff? Do you remember?
There were copy. I think there were 3 or 4 people, but there were Tully, I think one of them, but there were other people that were on it who may not have been in charge of the investigation, but knew about it. So the question is, does it taint what they were thinking? If they were thinking that, what Proctor was thinking, right?
Right.
I still want to see the email that apparently wasn't supposed to be disclosed because it was on a protective order of what Proctor said about Alan Jackson.
Oh, that part, yeah.
It wasn't nice. Maria Santos, again, thank you for being so involved in this case. If there's a time limit to retry this case, wonder why Beverly is rushing it. Michael?
Yeah, we've talked about this before, thinking maybe it's a calendaring issue with other big things coming, and I mean for the court, or maybe it's her own schedule. Maybe she's got big things coming. And on the other hand, maybe it's just, let's get this done. I think with these attorneys on both sides, it seems they will, it's like when you get a house, a bigger house, because you finally have room to move, you got room, and you fill it up with crap, no matter what size it is. These attorneys, I think, fill up the time, no matter how much it is, they will fill it up. So let's just truncate that time and get this thing to trial
and get it done. And sometimes attorneys need a little pushing about that. There's no doubt about that. Jam asks, why does Judge Cannoni believe everything the prosecution says? It's very frustrating, Michael.
It just feels that way, doesn't it? I mean, when you hear time and time again how she sides with them, when she uses the tone of apparent anger and disapproval and grave concern with things that the defense does, it just makes you think there's some bias there, and you shouldn't feel that way. Yeah.
Now the judges do have a rotation, as Dizzle's pointed out. They do have a rotation, and she can be able to move. But normally, even in that rotation, that lets you keep that one case. That happens when judges get moved up to higher court. Sometimes they have to keep the case that they're dealing with if it's a high-profile case. Massachusetts has a different way of doing things. While we do have other questions to answer, I want to go over some of the things that did get swept away in all this that we're having. This was a good one because this is kind of a question that kind of like answered itself by waiting a day. Wendy Wright said, I really enjoyed this channel. Thank you very much. Thank you for all the work involved. And to everybody who works with us, all of the producers, you know who you are. Missy Mayhew was here, and everybody else who's volunteering and helping us to help you to bring you this content. But ask, how long do you think it will take for the judge to decide on the motions? Well, that was last night.
Yeah, that's right. And we said pretty soon, pretty quick. Today was a flurry. There's still some stuff out there.
Yeah.
We got 3 weeks technically. So
yeah. Disney Nerd had a couple questions. Let me do. There's an A and a B. because you're here again, and I don't want you to think that we didn't answer your previous questions. I hear that there's a police audit coming out shortly after the trial starts, and could it be one of her reasons? Michael.
Yeah, I don't know. I don't know anything about that audit, but just based on what I believe it would be, I'm not sure that would be a big deal unless the audit reveals some improprieties with some of the witnesses that are going to testify. I don't know. And what kind of audit is it? Is it a financial audit? Is it a credibility audit? Is it a case audit to see if there's been any improper police activity? I don't know. I don't know enough about the audit, but I'd be shocked if that's pushing her.
Yeah. And then the question B from Disney Nerd that we hadn't answered last week. Hanky Panky, she calls him. I'm sorry, that's Hank Brennan, but it's kind of cute. Now says that there's going to be 2 chains of custodies turned over. I feel like Massachusetts is behind on this. Most states already follow this with similar discovery laws, right, as to chain of custody.
Yeah. So what do you think about that?
I don't think the judge cares at this point. Right now, this is what you have, and since now what the defense has, they need to argue their conspiracy theory. They can't say, well, the normal remedy would be, exclude, right? And they can't do that. They just can't do that. So that's the problem. So, and she understood that. She told Alan Jackson she understood that the other day. So that wasn't going to happen. Let's see. Am I reading this right? Yes. Okay, Christine, I am from Massachusetts. I truly believe that there are some shenanigans going on with the powers that be. As of late, there have been many scandals involving law enforcement officers. Michael, you're on this because you've talked to people. Well,
I mean, we know about some of them. I'm sure if you live in Massachusetts, you know about many more. When I've talked to the folks there, not just like Keith, who was one of the Canton 9, those are the folks who were arrested at Walgreens. Why? Because they had signs that said Free Karen Reed, and they were charged with trying to intimidate witnesses somehow. I don't know, help me figure out how that would be intimidating to any witness. But nonetheless, they were charged. Ultimately, those charges dropped. But when I've talked to folks in the community there, they're just so mad at a broader problem. They are so mad, and maybe Christine is in that category, that Karen Reed is a symptom of a bigger disease, is how I've described it. And for those who live in that area, I think they get it.
Yeah, it's true. Kathy, new subscriber, love the content and comment. Thank you very much, Kathy. Appreciate it. Tell all your friends. All of you have to hit that like button. You're doing it. I'm watching it move up there. Subscribe and all, and hit that bell to get notified. Also, we've changed the settings.
Maybe you do, maybe you don't. But at least you got a better chance.
I have found one thing, that if I do it on my computer, I don't get notified. If I do it on my iPhone, I get notified. So maybe it has to be with an iPhone, or not an iPhone, but some kind of phone, some kind of mobile device that it works. I mean, we're still trying to figure out how the algorithm works.
Well, when you figure that out, get back to me.
Yeah, let us know. Touche has, are the rules for how judges write their responses to motions? She basically said in 3 pages that Dr. Russell was wrong, and in 1 paragraph that the Commonwealth expert is right.
Interesting observation. Yeah, I mean, there's really no rule, and some don't even bother to explain. And the reason they normally do take some time to explain is because it might be taken up either as a new trial motion or an appeal after the fact, if there is a conviction, or some interlocutory writ if it's taken up before the final case is resolved. So it's CYA is what it is. They need to be able to explain themselves, Lucy, because if it's looked at by a higher court, they got to work on it. They got something to protect their reputation and their decision.
Now, Avid Events also has a question for you, Michael. Can defense bring up the Richard Glossop case? That's the U.S. Supreme Court case that they said this.
No.
A lie is a lie, no matter what the subject, and the prosecutor has a duty to correct the lie in trial.
Yeah, no. I mean, no. Obviously, that's appellate material if it were to get that far.
If it were to get that far, yep, that's right. And then Alify also asks, well, the defense asked for all relevant material to be preserved, right? Anything related to touching upon, because you don't know as a defense attorney exactly what's out there. Why didn't the Commonwealth think the Sallyport video was relevant? Weren't they considering the car relevant? What killed John O'Keefe, according to the Commonwealth, if that's the theory then?
Yeah, it's so stupid. It's mind-boggling. That's the murder weapon, if you believe the prosecution. Why would you not think anything connected to its investigation, examination is important? But then, why would you not search, go into the home at 34 Fairview? I'm telling you, if somebody dies on my front lawn, pretty sure the cops are going to be quizzing and getting a search warrant for my house. I'm pretty sure of that, right?
Right.
Unless they see, some obvious reason for the murder or death. Was it domino? Was it some wild deer? Why would the cops not look at 34 Fairview? I mean, that's the kind of stuff that causes people to say there's a conspiracy. I don't know if there was or wasn't, but that's the kind of stuff that makes you wonder, because they're all cop friends that were there that night and lived there.
Yeah. Hi, Afton. Afton, your name has been mentioned in vain, by the way. Afton's here like about 7 times. People can attest to that, right? We're not just making it up. I mean, we did mention you. We're glad that you joined us. We've been going for about an hour and a half now, so you're probably all tired of us. Anyone has any other burning questions that they want answered tonight? Because
that they just can't go into the weekend without knowing the answer to.
Yeah, please, because we think we've touched upon everything today. Was such a busy day. We know that the in limine motions are coming. I think there's going to be a reply from the Commonwealth to
the supplemental. Okay, that'll be interesting, and it'll be somebody who's the Chiron expert, and they're going to use my story that we just changed the font color to make it more readable.
Well, okay. Well, then they're watching Justice Served TV. I mean,
So what else is happening next week? We think we're going to have a couple of very good guests.
Right.
We think Aiden may make an appearance. We'll chat with him about what's going on. And I am going to get his attorney on at some point.
Right.
That I'm confident in. We'll see with the way things are progressing, maybe sooner rather than later, if he's not truly going to be on the defense team, and it looks pretty likely he ain't.
Right.
Then it makes it less messy for him to come on and talk with us. So
right, that would be great. I mean, also Aiden did have a local attorney who did a lot of talking in the courtroom. But we'd love
Drabel, I believe is. I know I'm probably mispronouncing it, but I think he did a great job. I think he made some good arguments.
Yeah, I think he did a terrific job. And then I know, Missy, we had a full week of guests that we were going to invite, and all of a sudden my mind has gone to mush.
Let's see.
She's about to answer us. I know she's about to answer. You want to get on the stream, Missy? You want to be shown so you can answer? Come on, you are our first guest. You can do it.
There we go. Hey guys, can y'all hear me?
And there's Pixie.
Yeah.
Yep.
And she got scared. She's camera shy.
Yeah.
Yeah.
She's in the bird witness protection program.
So let me check. We're working on a date with Aiden for next week.
Yep.
He just said sometime next week. So once I nail down the date, we're gonna announce it. I think we were gonna work on maybe some jurors. I know Michael was talking to Bederow a little bit. Mark Bederow.
Again, as I just said, that may or may not happen next week, but I think it's going to happen.
Hi, guys.
Yeah.
I look terrible.
Yeah, we're going to reach out to a couple of the jurors that have given interviews, or one juror that's given interviews.
Well, that's right. Yeah.
But we have other questions, believe it, because we come from a lawyer background when we ask these questions, and from pretty high-profile trial experiences. So our questions may be a little bit different.
Bowtie Ronald, is that who we're talking about? Bowtie Ronald?
Very interesting. And there's also an alternate juror who's given a statement. I don't know if she's been on any shows, but she's given a statement.
She's the attorney, right?
Yeah, she's an attorney. Yeah,
that'd be interesting.
Okay. Something about that. And then I think there was a fourth thing we're talking about, as you mentioned, we want to have a mock juror on when we try this case. And Michael's reached out to a couple people already.
A couple from the scene. We want to get a mix, obviously. Most of the
I'd love
folks
to
hanging
have
out
Keith back, some of the locals that Michael talked to at the impromptu
Thanks
town
for making
hall.
it count. Appreciate that. I normally don't endorse addiction, but I'm okay with that. So
Yeah, yeah. I know you want to talk. You want to talk to maybe Keith will come on, or maybe Keith's,
Yeah.
Or
Dina,
the Glarer,
or
Will,
right? Will.
and Dina. Wanted to. I was supposed
By
to
the way,
work on
watch
that
their
today.
channel. Will the Glare, he's been really endorsing our channel. We should endorse his
Yes.
yeah,
channel.
we've made reciprocal promises to do one another's shows, so we'll get those
Hi,
set up.
chat.
And then I know next Friday night I plan to take off, so you may have to have a either we're going to have a pre-recorded show next Friday night, or you're going to have a guest host.
We'll see what happens. Yeah, if it's
That's what
Friday
Linda
like
said
this,
this week.
yeah.
Today we were
Yep.
supposed to be off, and I was supposed to work on all the bookings, and I didn't. I
Well.
worked on thumbnails and tweeting and all sorts of stuff. But yeah, Dina, I'm obsessed with Dina. I would love to have her on the show.
Yeah,
Yeah.
She was a
problem.
blue glasses.
Yeah, we talked about her glasses, and she got those because she kept losing her glasses, like a lot of us who have readers do.
Mine are blue too.
And yeah, so
They're
she found
Tiffany.
those. Nice. So she's
I went
she's now.
splurge.
We can have a poll. We can say whose glasses are better, Doug
no.
Weinstein or Dina's glasses, and maybe I'll wear my red glasses that day.
Oh my gosh, it's a competition. The gauntlet's been thrown down. I'll have to step it up.
Yeah, we've been thrown down. We have to make sometimes a little bit of light, because this is a very serious situation, very serious case. And sometimes it's so stressful, even for us as commentators. And I can't imagine what the lawyers are going through, what the family members of both parties are going through.
Yep. I mean, we've always tried to, have as much fun as you can when you're talking about death and destruction. I mean, it's just, it's kind of a defense mechanism, right?
It is a defense
You can go right down the rabbit hole with some of these cases.
Yeah, it is a defense mechanism.
We do it not out of disrespect in any way. That's for sure.
Absolutely not. That's why we're spending all of our time talking to you, because we think it's important to bring light on these cases. And, we tried to do it in ASAP Rocky. And by the way, we are still on that. We will be throwing down the gauntlet. We just wanted to get past this little Karen Reed flurry that's going on. And then I think it's going to be like a couple weeks where they're going to really get ready for jury selection. There won't be much happening in the court every day.
Yeah.
Because the district attorney there has not answered our questions about the ethics review of Relly, and we will be inviting him on. We're going to go back to that. We'll see what happens, but we do want to have a whole panel on that when we have one day that we can take off from the flurry of Karen Reed that's going on.
Yeah.
All right, then. Should we wrap it?
Okay, so Missy, why don't you give us the words of wisdom tonight?
Yeah.
Please it really helps us get into the algorithm. We're a small channel, but we're mighty. We're trying to grow. So subscribe, become a member if you can. Hope to bring a lot of really good content next week.
Cool. All right, then. Well, I will see you then. You guys have a great weekend. I'm Michael Bryant. Try to do the right thing.
And I'm Linda Kenny Bodden. Together we are all Justice Served TV. Thanks for joining us. We'll see you next week.